of times and worst of times, policy best practices for program agreements, grievances, and termination. If you are not supposed to attend this session, now's your opportunity to hop up and go there. If you need help finding another room, I'm happy to help you do that. At the end of slides, there will be a QR code for a survey. If you could actually click on that survey and take it, it would be wonderful. I'd like to introduce the presenters for the session. I'm going to introduce myself. My name is Abby Church, and I'm the manager of the compliance team with community services at IHCDA. And I have Carol Canada here and Mariah Lane. And they will be doing the presentation, and they're very excited about it. And I just want to say there are several places built in for conversation and for questions. So we kind of want this to be an open conversation, sort of a presentation. So if you have questions, if you have anything that you feel is contributing to our discussion, that would be fantastic. So I'm going to have Mariah come up first.
Hello, as Abby said, I am Mariah Lane. I work in the Community Services Division and I'm a compliance monitor. So you may have heard from Carol or I if you have an ESG grant, HACWA, or any of the COC programs that you're running. We're responsible for compliance and monitoring for those grants. So one thing that we wanted to discuss and we feel like we get a lot of questions about are program agreements and then the process of termination. There can be some confusion on when can I terminate a client? Do I need to terminate a client? What are my rights? What are their rights? And then the process of going through grievances if they have things that they would like to bring to your attention. So those are the things that we're going to talk about today. We do hope that it can be like conversational. So if you have something that you feel like would be helpful for other people in the audience to hear, please raise your hand and share it. Just a quick question. Can you guys raise your hand if you work directly with clients? Maybe you're like a caseworker. Okay, that's a lot of people. And then any like other program staff, or you're more behind the scenes writing policies and things like that. Okay, great. We have a good mix. Our hope is through this, you can understand each other's perspectives. And this presentation is for both groups of people, so that's great. Hope I can move this. Okay. We're going to start off talking about program agreements. So program agreements are required for all of the housing programs with IHCDA. And also I want to let you guys know that all this information comes from either federal regulation, grant agreements at IHCDA, or things that we require through the programs. So every one of your clients, if they're going to receive housing, you should have them sign some sort of program agreement. And it should be kept also in their client file for compliance purposes. You want to make sure that your client understands what's in this program agreement. Now, I understand the intake process for you direct service people can be overwhelming to the clients. I'm sure you're having them fill out a lot of different things. There's a lot going on and being thrown at them and at you. It would be a great practice to give them a copy of this program agreement so that they can reference it later. And yeah, to the best of your ability, trying to, not just hand them, sign this, but explaining to them, these are the expectations for the client and then for you as well. And this is not like a standard form provided by HUD or IHCDA. It is something where you have a little bit of freedom with your organization and based on your program and the requirements, that it can look a little different. So I already touched on this a little bit, but why do we need program agreements? You want to set the expectations at intake to the best of your ability. So if everyone is informed of their responsibility when they're very first signing up for the program, there's less room for confusion, hopefully, in a perfect world, but there's less room for confusion when conflicts do arise. If something is happening with that client, they're not following the rules and regulations and expectations, they're not paying their portion of the rent. When you are doing case management with them, you can bring that program agreement back up and say, you did sign this, we did talk about it, you know, work with them of what can we do to help meet these expectations. And then if it does come to the point where you are considering terminating the client, and we'll talk more about that, then your agency actually has that document to cover itself, right? So if they come back later and say, well, nobody told me that information or that I had to do that, you do have something to show that was documented, that you did explain this to them, you did cover it in case management, and they did sign it. So some things to keep in mind. So we want to terminate only in the most severe cases. We're trying to let you guys know today that, you know, you do have the freedom to terminate clients when necessary. We want you to feel like you have that freedom. But only in the most severe cases. And we will talk about some different things with that. And then especially for VAWA protections, if you have tenants that are covered under those, you cannot terminate them solely because of the fact that they are a victim of domestic violence or stalking. In other words, you know, you can't say, oh, well, this is a lot of issues, I'm just going to terminate this client. That would actually violate their rights. So we just want to keep that in mind. I'm going to touch a little bit on the termination grievance policy portion. So this can be a separate form if you choose to do it that way. But a lot of times when we're reviewing agencies, policies and procedures, or client files, we see them combined with the program agreement. It's really up to you, however works best for you. It must be, again, reviewed with the client before they begin receiving assistance. They need to know what could get them removed from the program. It should also be signed and kept in each client file. And again, it can be unique to your organization. So whatever you feel would be best. But it must include these items over here. So you are required to provide the client a clear statement for the reasons why they are being terminated, and you'll want to do that in writing so that you have that documentation. They also have a right for that decision to be reviewed. So this would be like the grievance portion. If they totally disagree with their reasons for termination, if they have something that they want to bring to the attention of your organization, they have to be given the opportunity to present their argument, basically. And they have to be able to make everything fair. They have to be able to go to someone that they don't particularly have the grievance with. So however your organization is, we have big subrecipient organizations with tons of staff, or we have some that are 1 or 2 staff. But however you want to do that, maybe they have the opportunity to go to the board, just a different individual so that it's treated fairly. And then once their appeal is processed and the final decision is made, they have the right to a prompt written notice of that final decision. So if you have a shelter award, shelters are a little bit different in the flexibility that you have there, because there are clients living on site with other groups of people. So you may have different specific rules and regulations. And they must abide by your shelter rules and expectations, or they could face termination. So some ideas that we wanted to, you guys may or may not already do this. It would be a good best practice to post your shelter rules in a public space so that, again, everyone has access to them. And then if something's going on, if you're trying to do a little bit of intervention with a client, you can reference that at any time. You can take them over to the side and let them know, hey, these are our rules, and then start that conversation with them. And you could also post your termination and grievance policies. That way you can say that they had access to that at any time, and you can also go over that with them when needed. And then I did want to touch on the difference between termination versus eviction. So if you have like a rapid rehousing or permanent supportive housing program, and you hear that your tenant is being evicted because of a violation of their lease or something like that, you can still work with that client if you choose to do so to help them find a different living situation. Because that would be an eviction thing. But the termination would be them actually being terminated from your program and no longer receiving assistance because they violated something or there was a cause for termination with your program. Yeah.
So if they're being evicted because they're not following what they should do in the house with the landlord, you're saying we still can house them again?
Yes, as long as they didn't violate your agency's program requirements. So if you still choose to house them, you can help them find a different living situation and still keep them within the program. But it would kind of be up to you on what your policies say. And if that's something that you would want to allow, like if they weren't paying their portion of the rent or something like that. That would be up to your agency if you want to continue to find them a different situation, if you think you can work it out with them. And we're going to talk about some problem solving situations, but yes, that's correct. You could still keep them in your program.
So if they're not paying their part of the rent,
Mm-hmm. Yeah, so that's where we get into some tricky things that hopefully we're gonna converse about. But yeah, it's up to your agency's policy. You technically don't have to terminate them. You can find them another place. That decision can be up to your discretion. Now, if you think that you're gonna move them into a different housing situation and the same thing's gonna happen, that could be a different conversation. But yes, technically they could still be. Okay, that was a lot of information. So, do you guys have questions that you would like to ask so far? Or does anybody want to, since you all are from different organizations you've all experienced different things. Does anybody want to share any kind of situation with terminating a client or share what's in their program agreements and things like that, with the group? Just so you get some perspective. Sure, yeah.
I actually, yes. If you had this, I mean, they're going to involve.
Mm-hmm.
But that's also the information that help us. Do the population.
Mm-hmm.
What?
Document.
I mean, you're at a catch 22 there, like he said, you need to document that. But if you do, then it's gonna be in the file form. So maybe I would try to figure out a way to word it
Yeah, that's what I'm.
that it would still be there if you need it down the road, if you have to have a termination, right? But then not have it where,
Yeah. It'd be like 0.7 of the.
Yeah, yeah.
right? Because if your agreement says, if your agreement, your program agreement says XYZ, okay, for an example, if you're not paying your share of the rent, that is terms for termination. I mean, that's, a termination because you've agreed to that. But then after they're out of the program, you can later bring them back into the program. Just because you've terminated them doesn't mean that they can't come back.
Reason they're, it's the late. Like, once they're, that's just like if they had 2 years, even if they can wait a year or.
Are you talking about rapid rehousing type of? Okay. So if they received their maximum amount of assistance, that is different than them being terminated. So if they were only receiving rapid rehousing for, let's say, 3 months, and then they were terminated because of a violation on their end, I do not believe that there's a regulation that says there's a wait period for when they could re-enter the program, but again, that would be up to your organization and how you guys want to handle things. Yeah.
I'm just curious, how often are agencies getting subpoenaed their records,
Yeah.
for criminal proceedings? Like, I mean, I understand that, depending on your legal counsel, and how risk averse you may be, but does that come up often? Because our attorney would quash that, so we, or at least attempt to. And I just feel like we have to, unfortunately, use the programs far more often than we get subpoenaed for criminal proceedings. So I just wonder if we're shooting ourselves in the foot with a policy that's like 2 others that got, what we need to do.
Yeah.
It really has happened.
Oh, okay.
That's for a criminal proceeding, not like an eviction procedural administrative.
Okay.
I was gonna say, it may depend on the need.
Yeah, go ahead, you're fine.
As a grants analyst, it may depend on the nature of the crime, because even HUD's fair housing rules, they have a couple of specific crimes that make it to where you can't access any HUD-funded housing. But then outside of those defined crimes, it
Yeah.
sounds like you can, so long as then, okay, well, is the landlord okay? Is the subrecipients nonprofit agency that is working with the client, okay, with
Yeah.
helping.
And that would go back to their policy, what their policy is.
Right,
Because no matter what, when it comes down to it, we're going to ask, did you follow your policy? HUD's gonna ask, did you follow your policy?
Yeah. I would, yeah, my personal opinion, I would err on the side of caution for your agency. Again, like you're saying, you don't have to have pictures and things like that if you don't want to include those things, but yeah, I think keeping case notes is definitely very important, because if anything ever comes up, you're going to want that documentation to cover yourself. So however you want to do that, that is a unique situation, so.
I have a status on the program. And sometimes we need to terminate people from our program. And then what happens a lot, we give them a date on the specified participant agreement. That lets us know we not give them something voluntarily. And then if we try to evict them, our name is on it. So, where it would be a big deal, our agency. And we just went through this situation. And the property manager was on our side, because they're providing her the lease policy as well. But sometimes we need to terminate them even if they're not violating the lease. And it becomes a really big problem in trying to figure out how to get them out of the problem. And sometimes that turns into like a 3 to 4 month situation, trying to get them out.
That sounds like a legal situation there with, that you would work with your attorney.
Yeah, because so your agency on the lease, but you also should have the client sign their rental assistant payment agreement with your agency. And I'm wondering if that could be used. That would be illegal. That's above my expertise, of the law, but
I was just wondering if other
Yeah.
agencies have that same.
yeah, does anybody else have?
well,
that?
I was gonna ask, I'm interjecting here, sorry, but.
This is Neelafar. She works as our grants analyst for Hopwa and ESU, so.
Yes, hello. Okay, so the first thing I wanted to interject with was, for the person that had asked the question, is your agency either the owner or otherwise the landlord of that unit that the client technically would need to be evicted? And is that the reason why? The agency's name is also?
I mean, it's the same thing. They brick. Property.
Yeah, for PSH, yeah,
That's what it sounds like.
The client, so, less,
so, yeah, they've stopped.
It's not. Correct. So, yeah.
It's for POC, PSH.
Yeah,
Okay.
yeah, we do an iPhone. Sure. Our agency has the same, it's a holdover from Southern Plus Care. Only governmental agencies could have rental assistance and everyone else did leasing products. So, but we do a sublease, right? And so the landlord is still screening the tenant, they're still going through their background checks. And so when we notified, we are removing ourselves, we're breaking our lease, we were lucky to continue working with them. It's not easy. No. They're definitely, we try not, a lot of our properties, we just keep using that same. Oh, we do the same thing. Oh, we do the same thing. We try to get them, but there are also times when it's more expeditious for us to just back out, and you're more than welcome to take over the lease, any for the lease, 100% here. And then, yes, there are times when it's easier to write the skill there, and then not so much. And believe me, we go back and forth every year. What are the pros and cons to keeping this as a leasing project based on the system project? Because we're also able to place people in units who would never pass it. That's not really unfair. And so it makes it, and we like having the unit, to get out, then we can pop somebody else in there, like that. So there's pros and cons to both, and, we do seriously ask ourselves this every year. It was often the reason. But that's kind of what we use the suburbs, and the property, was aware of that, so it's on the front.
Thank you for stepping in and helping out with that one. That's what we wanted, is for you guys to be able to communicate with each other, because you know more than we do on the day-to-day types of things that you guys may struggle with. So I think it would be great for you guys to connect in between breaks as well, and give each other, that valuable information. So I'm going to have Carol come up now, and she's gonna dive more into the termination and grievance.
As you said, I'm Carol Canada, and I'm a monitoring, compliance monitor with the community services. So, let's see. We're going to go over to. What? Technology. Okay, thinking about terminating. All options must be considered, as we just briefly, talked about it. Terminating depends also on what your policy has in it and stipulated for it. Troubleshoot with your team and consult your leadership. We had some of the collaboration here just a few minutes ago, so great to do that. Consider changes you can make to build a better relationship. And sometimes you can do this and sometimes you can't. In a perfect world, we'd all like to be able to do that all the time, but it's not always feasible to do that. And then reach out to the IHCDA grants team, because Neelafar is
One of
many that can help you through, and maybe you another person that you can talk to that's out of the situation and give you some ideas. And then tips for termination. Follow your organization's termination policy. Again, policy, because if anything happens, it's going to say, HUD's going to say it, we're going to say it. Did you follow your policy? Document everything in case notes. Again, anything with government, you have to document. So document that information, keep it in your case notes, always have it there. Don't ever get rid of it. And if you feel it necessary to notify the IHCDA grants team, we're here. We're here to help. And if a client files a grievance, again, follow your grievance policy. And it's something that you've made up, that you've constructed, and you just need to follow it. And, obviously it can be updated yearly. And as you go through the times that you experience other situations and think, we need to put that in there, but you need to follow your policy. The next two slides are termination and grievance policies, one of many of them that we've gotten that are good. We just wanted to bring this up. And you'll see that also under the termination, it says termination does not bar the subrecipient from providing further assistance at a later date to the same individual or family. So you can do that if you have that in your policy. Okay. And then it talks about the different reasons for termination. And that's what you want to list in your termination policy, just so that you can go back to it. Then also it goes into the how to file for a grievance, the different steps. And that's what you want to try to make clear, because they need to know what to expect, and it just makes it easier for you to have that information to say, we're on step 2 or we're on step 3. Here's the grievance procedure that is also included in this. And you'll see that they have the different steps, who to talk to, and how long they will have to make a decision. And, what the final, step would be is, to, if there's a concern or grievance and they're not getting what they want, they could always contact IHCDA. Okay, here we go for discussion time again. Here's a few questions. So what termination prevention strategies have worked for you? Any thoughts there? Yeah, sometimes the unit or the property management or whatever, sometimes there's a conflict there. Sometimes, it's good to just try to get them into another unit. And that, relieves everything. Okay, what changes have you made to your agreements and policies? Is it a policy that it was made 10 years ago and it's still the same policy? Or have you updated it periodically? How do you collaborate with landlords to prevent eviction?
I, and you said that, okay, do you want to deal with this client again with me? It's usually with our clients, the stuff that they do, it's like, I put you in another unit, we're gonna go through this again.
Yeah.
What do you?
That's a decision you
Especially when they got kids.
Right. And that's where, you would, that's your decision, but maybe you also, include that in your policy for that to be there so that you can always go back to it. Because, I understand that, how many chances do you give them? If they're creating problems or destroying things, destroying the property, how many landlords can you get to work with you with that?
And you don't want to mess up the good relationship. But, some landlords,
Right.
they won't want to deal with you.
Right.
That's just the hard decision, but you do have a right to make that decision. Like if your policy says, if you get evicted due to property destruction or criminal activity, you're gonna be terminated from our program. Or like he was saying in the back, maybe they can give them one more chance at a different property. But unfortunately, that's just tough decision sometimes that has to be made. We want to let you know that you have the right to do that, if that's what's best.
We recently spoke with one of our subrecipients who they had been dealing with violent and angry tenants, and they didn't know that they could file agreements. They didn't know that they could terminate. They thought that they legally had to keep those people in their program. So we want to let people know that you absolutely can do that with these policies in place.
Yes, that's what it all amounts to, is making sure that you have your policy to cover what you're going through, cover the situation. And obviously, you're not going to have every situation in your policy, but maybe the overview of it, the major part of it, the situation covered in your policy. If you have terminated, was the client surprised being terminated? Yeah. So were they surprised because, they thought they would never be terminated? Were they surprised because they didn't get a notification that they were gonna be terminated due to whatever the situation was?
Some feel that, because they're on the program and we're supposed to help them, they feel.
That they can do anything?
You can't give it. I gotta hear.
So do you give them a written notice to let them know?
But that they're going to be put out,
You're right, they're gonna be terminated from the POC program?
that, and then we make sure we send something to, property.
So when they get the written notice, then
Then
they
they call.
and they're surprised. And that's where they're surprised at, right? Like, what are you talking about? I haven't done anything wrong, right? Yeah,
It's a solid.
so they think that just because that even though they're getting the written notice, that you will never follow through with it because they're on the program.
Yeah.
So do they ever, does it ever, change the, the behavior of what they're doing when they get that notice to where you think that, okay, they could stay in the program? Got worse? Okay. So then you do another notice? Is that what you do?
So we'll terminate it.
Okay,
It's contract, it is funding like intervention between the.
Sure.
The interaction, I've only had it happen once, but, the interaction. Once they got, they knew that there was not any talking out of it, but.
so I'm curious, is it common to, after you've terminated a client, is it common that maybe in a month or 2 months or whatever it is, that they come back and you reinstate them? I mean, you sign them back up into the program? Is that common? Well, and it's allowed to happen. I mean, for that, that one policy in that, I mean, they do it, but I'm just wondering, how common is it? It happens, but it's not as much as what you think. Is that it?
They would have to. Back through
Right,
coordinated entry and everything, so
Right.
it's a way.
right. Yeah. Okay.
Yes.
Yeah, that's a great idea. It's a way to work within the group.
I was just gonna say, because you mentioned about having put people back on coordinated entry, we just within the last year in our coordinated entry policy procedure, there's a transfer policy. So you have the ability to reach out to other people and you're like, they're about to lose their housing. And because different units have different things, right? We have a lot of scattered site inventory, right? And so, but there might be a project in that has like secure entrance and that helps control who's coming in and out of the unit. And so we might be like, hey, if somebody's ready to wants to be more in a neighborhood and less in a project, and then, we do a spot there. So that's allowable. But you have to take a look at your coordinated entry, policy.
Yeah, because you would have to, like the counties that we serve.
And there's also a transfer policy across, regions.
It's really good. It's really good that you're working together
And,
with that.
we're don't have near enough inventory for the need that's out there, right? So I don't see that it's done, but it is a possibility to reach out to other unions. Or even other, agencies within your.
That's one way to solve the problem. Yeah. Okay, then what if a client has been terminated, could make a complaint to ICDA if they were unhappy with the results of the file grievance? Well, then we would be asking, do you follow your own termination and grievance policy? Remember I said that's what I would say, that's what we're gonna say. Did you follow it? And that's probably the first thing we're gonna ask. Did you follow your policy? Did you document every step of the process? Again, document. Did you violate the rights of the client? And then can you provide this evidence to IHCDA if an investigation occurs? So you want to have this information, the documents and all. So if something does happen, that an investigation is going to be happening from our side, you want to be able to have all those documents to show us what really happened and not he said, she said situation.
So it's case notes, notices, like 30-day notices.
Yes, absolutely everything. Everything that, you can put in case notes or any written notices or anything, you just want to make sure that they're in the file. And then the final tips and takeaways that have been from this presentation is review and update current policies and procedures. Are they clear? Are they fair? And I would just add, is it something that after you've thought about it, what else can you add to it to make it more clear? Audit your client files, and that is, does every client have a signed program agreement with termination and grievance section? And I'm just going to add to the point of, since I am a monitor, I'm sorry, that all the documents that you have for the clients that need to be signed and dated, need to be signed and dated.
Please.
Please, need to be signed and dated. Because that's what makes them accurate. Okay, someone can put a document in the client file and it's not signed and dated, and is that a template? Is that an example? It's, that doesn't show any accuracy in, being a compliance monitor is going to be noted. So just, make sure everything's signed and dated. And review intervention and termination prevention strategies with the team. That helped tremendously. Is there room for improvement? Again, remember I said, if there's something as you're going through these different situations and think, we could add this to our policy, write it down so that when it comes down the road where you're looking over your policies, you can add those in.
Have you all ever been reading like a contract or a policy and you thought, this is oddly specific? Because that something really, really strange happened and that organization chose to put that in the policy. We are saying if something very strangely specific happens, go ahead and put that in your policy, because chances are that could happen again, or that could happen to another subrecipient that might ask, for your help with writing their new policy. Because strange things happen and strange things can happen again and again, and it's good policy to write good policy.
And then communicate with IHCDA. Is this a consistent issue? Do you need guidance? We're always here to help. Our, grants team analysts, they're superb in working through something with the subrecipients to help them through, to get an answer. And if they don't know it, at that moment, they're gonna research it till they do know it and get back to you. Keep your staff and others safe. Is termination necessary to ensure safety? So, as you were saying about some of the situations back there, yeah, you have to be safe and you have to, keep your staff safe. So we want to say thank you. And if you have any questions, by all means, we're here to help. And Abby
Hello.
is our manager and her email is there. Mariah and I are the monitors, compliance monitors that I know you guys, kind of like don't want to hear from us, but we try to make it painless as possible.
And they're very nice people. I promise.
Any questions, anything that you want to add in to what we've talked about?